Hello. We need to speak about demand letters. A demand letter, also known as a letter before action or a pre-action letter, is a formal notice demanding that the recipient perform a legal obligation. It's typically used to persuade the recipient to take or cease some action, rectify a problem, pay a sum of money, perform under a contract on a specific term or on specific terms and under a specific period of time, or to revoke a waiver of rights, or simply to provoke a reaction which the writer can later use to his or her client's advantage. A typical demand letter gives the recipient a chance to perform the obligation without being taken to court. Indeed, in many instances, it encourages the recipient to settle the matter. Overall, demand letters should be a firm statement of the client's position and intentions, and while demand letters are often written to intimidate, they should not bully the recipient. So here are some tips when you are writing a demand letter. Use plain English whenever possible to ensure that the letter is understood. Adapt the content to the recipient. Be polite and avoid personally attacking your adversary. Avoid common errors such as using inflammatory language or misstating the facts of the law. And finally, collect good examples of demand letters that you have come across in your practice as templates which you can use in the future. Thanks. Prima facie. This Latin phrase prima facie is troublesome for a number of reasons, not least of which because of its pronunciation. Essentially, though, what it means is evidence that's sufficient in law to establish a fact unless it's proved otherwise. In other words, it is considered to be true or at least adequate on first appearance, absent other information or evidence. It is often used in litigation in the phrase prima facie case. A prima facie case signifies the establishment of a legally required rebuttable presumption. In other words, a prima facie case is a lawsuit or even a criminal charge which on its face appears to be sufficient and supported by the requisite minimum of evidence. An example of this in use would be the plaintiff presented a prima facie case for breach of copyright, and when the matter proceeded to trial, the plaintiff successfully proved his allegations. In a similar way, prima facie evidence is evidence that is sufficient to prove a factual matter at issue and justify a favorable judgment on that issue unless it's been rebutted. And a sample of that usage would be the side contracts were prima facie evidence of knowledge. Thank you. Obiter dicta. We will be talking about the Latin phrase obiter dicta. Now, this expression literally means said by the way, or statements made in passing, and the phrase obiter dicta describes statements, remarks, or observations made by a judge in a ruling that are tangential or supplementary in deciding the case. That is, they refer to matters that are not essential to the decision. Although they are included in the body of the opinion, these statements are not themselves legally significant. That is, the judgment of the court would stand on its own without them. The reason that they are there is to clarify the legal principle which the judge proposes to apply in his or her judgment. So these statements, illustrations, or analogies that make up obiter dicta are not binding, although they can be strongly persuasive because they let us know what the judges are thinking and how they might decide in other cases that have slightly different facts. Now, the weight given to obiter dicta usually depends on the seniority of the court and the eminence of the judge in question. Now, the term obiter dicta is actually plural. The less common singular form is obiter dictum. This phrase is usually shortened as merely dicta or dictum in both the US and the UK. However, sometimes we see the phrase shortened as obiter. But my suggestion to you is to use the full phrase obiter dicta whenever you want to talk about statements which are made in passing by a judge. Thank you.